Okay, guys, so I received your responses to the little poll that I put on Telegram yesterday, and I'm a little concerned that most of you are bordering around 6 and 7. So I thought that I would make this video to sort of take you through the reasoning in ACB in a little more detail, right? Because I think we were constrained yesterday from discussing it in more detail by the amount of time we had. Okay, so the purpose of this video really is to help you get a better grasp on how to tell the difference between ratio on the one hand and dicta or obiter on the other hand. But I would like to preface this video by first telling you that there is no need to panic if you cannot do that. Okay, if you cannot find a clean, bright line between ratio and dicta, why do I say don't panic? Okay, a few reasons. First, like we've talked about yesterday, what amounts to ratio and what amounts to dicta really very much depends on how you frame your issue, and as a result, how you answer the framing of your issue by way of your holding. Okay, so there is no one fixed rule saying that, hey, for this particular case, this is dicta, this is ratio. Whichever side a certain legal principle falls on depends on first how you frame your issues and how you then phrase your holding. Now, the other reason for you to not panic is that there's often an overlap, right? And sometimes it's really not easy to tell what's what, even from the perspective of a very experienced lawyer. And last but not least, take comfort in the fact that as you go through law school, in the more advanced years of law school, and when you go out to practice in the future, very few people are going to come and ask you, hey, what's the ratio of this case? What's the obiter of this case, right? More often than not, in your later stages of law school and out in practice next time, you will be asked or you will be required to identify important points in the case. Okay, people are just going to ask you, tell me what this case stands for, or tell me what are the important points. Very few people are going to come and say, hey, give me the ratio and then give me the dicta. All right, so all in all, try not to panic too much if you can't tell the difference at this stage. But having said that, right, let's go through ACB and Thomson again in a more granular manner, so that I hope at the end of this video you walk away knowing more than you did when you left your answers to the poll. All right, okay, so I think most of you would have no issues identifying the issues. Okay, pun not intended. Okay, most of you would have no problem identifying the issues in Thomson Medical. There are 3 issues. Okay, the first one, whether or not the appellant was entitled to the upkeep claim. The second one, whether or not loss of autonomy could be a claim, right, in and of itself. And third, whether or not the appellant ought to be awarded punitive damages. Okay, I think that much is clear. Now, I don't think also that you will have many problems with the holdings. Issue 1, quite clear, the court said upkeep claim should not be allowed, right? Issue 2, in terms of the question as to whether or not a loss of autonomy claim should be allowed, the answer, or rather the holding, is a little more nuanced. Okay, if you want to, put it more specifically, I think there are 2 levels to the holding for issue 2. The first level essentially says, look, no loss of autonomy as a claim in and of itself. Okay, in other words, loss of autonomy is not an actionable hit of damage. Now, the second, so to speak, tier or level to the holding for issue 2 is that the court actually said, look, okay, notwithstanding the fact that I'm not going to give you loss of autonomy as a claim, I am going to allow a claim in what we call a loss of genetic affinity, right? Likewise, the answer or the holding to issue 3 is also a little more nuanced. While the question was whether punitive damages ought to be allowed, in this case itself, the court sort of answered the question on 2 levels, right? So the first level was the court saying, look, we can actually allow punitive damages in cases of negligence. But in this particular case, the court said, no, the appellant is not entitled because the appellant didn't meet the test that you need to meet in order to be awarded punitive damages, right? So bear in mind that sometimes holdings to issues can be nuanced or can be tiered, as is the case in this matter, right? Now, so let's look at the ratio for the first issue, whether upkeep claim should or should not be allowed. Now, always remember what a ratio is. A ratio is the main reason for the court reaching the holding. Okay, so phrased differently, if you want to find out or if you want to get a quick idea of what a ratio is, ask yourself this question: why did the court reach this holding? Now, so the question here really is, why did the court say the upkeep claim should not be allowed? And I think for issue 1, the ratio is quite obvious, right? There are 2 main reasons for why the court said, no, I'm not going to allow you upkeep claim. And these 2 main reasons are, like what we discussed in class, rather philosophical or moralistic in nature, right? So the court is saying that, look, first, the obligation to raise a child is a moral obligation that is at the heart of parenthood. Okay, and therefore, this kind of moral obligation cannot be translated into a legal loss, right? You cannot equate this obligation to raise a child with, let's say, an obligation to repay a debt, or an obligation to, let's say, not destroy a house that you're renting. Those are legal obligations, but raising a child is not a legal obligation, it's a moral obligation. So this is one of the reasons why I cannot allow you to claim money, right, for having to fulfill a moral obligation. So that's the first reason, right? The second reason is somewhat similar. The court is saying, look, this notion of an upkeep claim is not consistent with the nature of the relationship between a parent and child, because a parent is supposed to love a child, right? A parent is supposed to bring out the good in a child. If I allow upkeep claims, I'm going to promote a situation where next time down the road, somebody comes to ask me for an upkeep claim, and this somebody may be encouraged to play down the benefits of having a child and to exaggerate the disadvantages of having a child. And that kind of exercise can be very destructive for a parent-child relationship, right? So see these 2 reasons as reasons that directly contribute to why the court said, no, I refuse to award an upkeep claim. All right? Okay, so let's move on then to the obiter for issue 1. Okay, so you will realize that in the reasoning directed at issue 1, the court actually talked about more than these 2 moralistic reasons we talked about earlier. The court actually delved into a discussion on the categories of reproductive wrong cases, right? So there's wrongful birth, wrongful life, etc. And the court added this 4th category called wrongful fertilization. Now, think about it. Is this discussion on reproductive wrong cases obiter or ratio? I would say it's not ratio, because this whole discussion doesn't contribute to the court coming to the decision as to why upkeep claims shouldn't be allowed, right? So again, if you were to ask yourself, why did the court say no to upkeep claims? This whole discussion on reproductive wrong cases adds nothing tangible to the court arriving at that discussion. And I think the court actually delved into this discussion on reproductive wrong cases because it felt like it needed to slot its current decision into one of these existing categories, right? And when the court felt that, hey, today's decision doesn't seem to fall into any of these existing categories, the court then went one step further to say, okay, I'm going to create my own category so that I can slot my decision into it, right? It's somewhat like an exercise that the court undertook to justify its own decision. All right. Now, there's this other line of reasoning or discussion about whether or not the upkeep claim would be allowed if the appellant sued in contract instead of tort. Again, I think that this is very likely dicta because this line of discussion, entertaining this thought of whether or not things would have been different if the course of action was different, it's totally immaterial to the court reaching the decision of not awarding upkeep claim. All right? Okay? And I would say that this is all dicta because at the end of the day, the appellant didn't sue in contract. It's just hypothetical, right? Okay. Now, if the appellant did sue in contract, okay, alongside tort, then I would say this reasoning, right, as to whether or not the claim in contract would lead to an upkeep claim would become ratio. But because in reality, appellant never sued in contract, this whole discussion becomes hypothetical, becomes merely academic, and therefore cannot be considered as ratio. All right? Okay. So let's move on to deal with issue 2, the question as to whether there can be a claim for loss of autonomy. Now, the holding in this case, like I said earlier, is a little nuanced. There are 2 tiers to it. First tier, loss of autonomy cannot be a head of claim in and of itself. Second tier, the court said, look, even though I'm not allowing you loss of autonomy as a claim, I will award you damages for what we call loss of genetic affinity. So you ask yourself again, right? Why did the court come to this holding, right? Why? Okay, so why is the court saying loss of autonomy cannot be an actionable head of claim? And I think the answer to that, again, is quite obvious, right? If you read paragraph 115 onwards, you will see the court giving you a number of objections, in this case 3, as to why it's refusing to recognize loss of autonomy as an actionable claim in its own right. Okay, so there's the conceptual objection, there's the coherence objection, and there's what we call the over-inclusiveness objection. I think we went through this in class yesterday, and I think it's quite apparent to you how these 3 objections form the reason as to why the court is saying no to loss of autonomy, right? So it answers the question directly as to whether or not the court should award loss of autonomy, and because it answers the question directly, it is ratio. Okay? Now, so the court actually then went on to talk about how loss of autonomy is still valuable because it kind of works in the background, but it's not the direct head of claim. The court then went on to say, look, what the person is losing here, or rather what the appellant is losing here right now, is not technically autonomy, but a loss of genetic affinity, okay? And realize the court went one step further to explain why there was a loss of genetic affinity. There was a loss of genetic affinity because, okay, the appellant wanted to have a child with her husband, not just any child. And by having a child that wasn't born out of her husband's sperm, she has lost this genetic bond, she has lost this desired affinity, and therefore this concept of loss of genetic affinity is something that can be claimed on. All right, so you realize how this line of reasoning again goes directly to answering, okay, why did the court allow loss of genetic affinity? Follow? Okay, so as a result of that, because it answers the question directly, it can be considered ratio and not dicta. All right, so we go on to look at dicta, or rather obiter, for issue 2. I think this question came up yesterday. Somebody asked whether or not this part of the judgment about how to quantify compensation for loss of genetic affinity should be considered ratio or dicta. And I think my response was, this depends really on how you frame the issue and how you frame the subsequent holding, right? Now, let's work with this specific framing of the issue and holding, okay? Now, if we were to frame our issue, or rather if we were to frame our holding this way, okay, I would say that this whole discussion about how to quantify the compensation is not dicta, it's obiter, right? Because the holding right here simply deals with whether or not there can be a claim for genetic affinity. Okay? And if we had framed the issue differently, rather if we had framed that issue as such, how much compensation should the appellant receive for loss of genetic affinity, right? The holding would then be the appellant should receive 30% of the financial costs of raising baby P. Then I would say, okay, This part here would amount to ratio because it directly answers the question, i.e. the issue of how much must be compensated, right? But in this case, because we chose not to frame the issue and the holding from the perspective of quantum of compensation, I would say that this discussion about quantification is not ratio, but rather obiter. So this is a very good example of what I said earlier, okay, about how the line between ratio and obiter can sometimes be blurred depending on how you phrase or frame your issues and your subsequent holding, right? But I do invite you to think about this, okay? While this, in this particular context, is not ratio, do you think this is an important part of the decision? I would say it is, because this part, right, how to quantify damages or how to quantify compensation in cases like that will be very useful guidance to litigants in future who bring a case of a similar nature to the court. All right. If I were a future litigant wanting to make a claim against a defendant for this exact kind of situation, I would then refer to this auditor to say, look, I know that method 1 and methods 2 have been rejected by the court, and if I want to quantify the kind of damages that I've lost, I would immediately turn to method 3. Okay, so while not ratio, this part about quantification remains to be an important part of the decision. So this also highlights an important point, right? Okay, we can't always say that we should ignore auditor, or that obiter is always useless, okay, and only focus on ratio. No, okay, because sometimes important principles that can be valuable next time down the road is actually found in dicta or obiter, right? Okay, so still on the obiter for issue 2, I think there were also some other discussions that the court delved into relating to the various theoretical basis for awarding losses in the situations of, loss of genetic affinity, yada yada. Again, all these, I think, very likely obiter because they don't directly answer the question as to whether or not the appellant is eligible for damages in loss of genetic affinity, right? Point 1 just talks about the theoretical basis, not relevant. Point 2 and point 3 here, point 2 and point 3, they are actually talking about, the differences between upkeep costs and compensation for loss of genetic affinity, right? What the court is essentially saying is that if I award you upkeep costs, I'm awarding you compensation for monetary loss. You lose money for having to raise a child. Whereas if I award you compensation for loss of genetic affinity, I'm not awarding you for a monetary loss, okay? I'm awarding you for, like the name suggests, a loss of that genetic affinity. Splitting hairs, the practical result is the same, right? That the appellant will be awarded compensation, but the basis on which the court awards this compensation is different, okay? But again, like I said, all these don't relate to the direct question as to whether or not the appellant ought to be awarded, or rather whether or not the appellant ought to be compensated for a loss in genetic affinity, because they don't relate to this direct question. They are obiter, right, and not ratio. Okay, so moving on to issue 3, punitive damages. I think that issue 3 is likely the most straightforward of all 3 issues, okay? The question here is whether or not the appellant should be awarded punitive damages, but you will realize, like I said earlier, that the holding is a bit nuanced. There are 2 parts to it. First, the court is saying, look, we can award punitive damages for a claim in negligence, okay? That's possible. Second part, the court is saying, notwithstanding the fact that we find it possible, in this particular case, the appellant ought not be awarded punitive damages. Okay, so let's deal with it maybe in a stepwise manner. All right, so the first part, okay, where the court held punitive damages can be awarded, right? Ask yourself, in order to identify the ratio, ask yourself, why did the court say punitive damages can henceforth be awarded? What's the reason for the court coming to that decision? And I think that reason is made quite clear from about paragraph 157 onwards, right? Where the court said, look, for the longest time, the position on punitive damages in Singapore is that it should not be awarded, right? Unless the conditions or the three conditions, in this case called rooks, are met. Okay, but the court also went on to say, look, rooks is very outdated law, right? First, it's very old law, and second, these three conditions that were set up in rooks, they are very illogical and they're very arbitrary, they're super random, right? And because of that, we think rooks is not a very good piece of law to follow. It's not very good guidance. Therefore, let's replace rooks, okay, with a more appropriate rule that we are going to come up with today, which is I will award punitive damages if the conduct of the defendant is so outrageous that it warrants punishment, deterrence, and condemnation. Okay, so this whole discussion about rooks is exactly what led the court to decide that, hey, going forward, punitive damages can be awarded because rooks is bad law. We need to replace this bad position. Therefore, let's take on this new test, okay, or let's set up this new test to allow punitive damages to be awarded in future. Okay, so I would say that this entire line of reasoning would be ratio. These parts here are also ratio because these parts here directly explain to you the situations in which punitive damages can be awarded down the road. Okay, now, so this part here I think is ratio that answers the second part of the holding, right? Why? Why is the appellant here, in this case, not entitled to punitive damages? And I think the answer is really, really simple, right? They are not entitled, rather than the appellant is not entitled to punitive damages here in this case, because the conduct of the respondent, i.e. the clinic, is not that outrageous. Okay? So I would say issue 3 is a little more straightforward in terms of discerning between ratio and obiter than issues 1 and 2, right? So let's talk about obiter for issue 3. So there is some other discussion in issue 3 about the function of punitive damages, right? Whether or not it's need to be punitive, whether or not it's permissible for something in civil law to exercise some sort of punitive function, all this talk, I think it doesn't directly contribute to the question of whether or not punitive damages can be awarded in future, or whether or not this appellant here in this case ought to be awarded punitive damages. And because, like I said, it doesn't contribute directly to the question at hand, it's simply going to be regarded as an obiter. All right? Okay, so please remember the inversion test. I think it might be a bit tricky to apply initially, but I hope you got a sense of how to apply it in the exercise that we did yesterday involving the divorce case, the ATV and ATU, something like that. I can't remember the exact name. All right. Now, again, I want to stress, don't panic if you can't get it yet. Okay, you will definitely get better. Okay. Also, don't try to get so hung up about identifying ratio, identifying obiter. I think what matters most really is that at this point in time, you can identify the key principles in the case. Okay. At the very least, always think about whether or not there is one rule from this case that stands out and which can be applied in future cases. Right? That's the most important thing to identify. And that may not be ratio, that may be obiter. Okay, just like how we saw the point here about compensation, right? Hold on. Here, right? We discussed how this discussion about compensation, while not necessarily ratio, can take on a lot of importance when guiding lawyers in future cases of the same circumstances. All right, so at the end of it, I'll always just think about whether or not there's one rule that stands out, one rule that can be applied in future cases, right? And think about what key principles underlie that rule. Okay, so